My firm has said that if Carter comes in as proposed, and it looks like from what was produced yesterday that's what they're still proposing, we will not be doing legal aid.
We all have a sense that access to justice is critical, and we all have an awareness that the poorest people in society will be affected by these measures.
The situation is critical, and the only people who are going to be able to save it from complete disaster are the practitioners who are left, of which there are very few.
A very warm welcome to everyone here, and I suspect many people here aren't simply here for themselves. I suspect they're also representing large numbers of other people. I think we call the numbers here a magnificent turnout. Are we, that is all the sort of people who gather here and who want to see something done in the interest of justice to prevent the horrors of the Carter reforms, are we hostile or inimical or in any way unfriendly towards the Law Society or the CLSA? The answer is no. But I suspect that if the Law Society were charged in front of a People's Revolutionary Court with the charge of representing solicitors, the defence solicitor on duty would have a very easy morning. The market we trade in is one actually created by the government. It's a closed and restricted market. And the Carter proposals basically are pretending otherwise. They're pretending somehow that it can be equated to the broad free market, and therefore if you're against price competitive tendering, somehow you're against the spirit of the moment. Absolute rubbish. Now, I say to the Law Society and ask, what actually is your principal position on price competitive tendering? Now, I've looked at the CLSA response. I read it to be against price competitive tendering, and I think that means to say we are on board, we're all heading in that same direction. The numbers of solicitors like our good selves, which make up the critical mass you have to deliver a defence service, is going to drop away. We have reached a point in affairs with the criminal defence system where many say we no longer care, where if something is not done effectively, there will not be a criminal defence system. And if there isn't that, well, it's a shame for the country as a whole. When some rather vulnerable, underprivileged individual, hardly able, perhaps best to represent himself or herself, maybe from a minority background, they will come before the court and they will be represented by a DCW, designated caseworker, because the prosecution will be represented by a designated caseworker. That is their latest proposal. You sacrifice standards, you sacrifice quality, and you dumb it down as far as you can, all for saving, allegedly, money. Now, if we want to go down that route, I guess we can sleepwalk on. We will have those who will say, you never know, Carter might yet end up being dead in the water for some reason or other. No. Not unless we make sure it goes down in the water. I guess, had it not been for Cardiff, we wouldn't be here. Because, of course, Cardiff decided they were going to start moving. They started deciding to be shakers and makers, and they have done something.
The reason why we started off all the action was that in the summer, I think everybody realised what Carter was going to do to us. We were being given no direction from the Law Society, and therefore we felt that we must do something, which is why we decided to take the action. We realised that probably, although Carter was our problem in the future, the immediate future was going to be very problematic because of the changes in relation to the applications for legal aid, namely means testing. We were told that in the Magistrates' Court area, means testing would be reintroduced. The access to justice issue was extremely critical, and we felt that far too many people would be being removed from access to justice. Of course, if you are a multi-millionaire, you ought to pay for your legal representation, but not if you are an ordinary working-class man earning £20,000 a year who has substantial debts and a very real inability to pay. It is the profession who have asked for this meeting, the profession who have got together and said, we must do something. I feel that possibly to quote David Hockney, who is not exactly a person known as being a politician, this government represents all that is mean-spirited, and the trouble is they think they are doing good. All of them know nothing about social justice, and I think so far as the means test is concerned, I think that that is definitely contrary to social justice.
Andrew Watts-Jones, Wood Audrey & Ford in Chippenham, Wiltshire. My firm's stopping doing criminal legal aid, and we're all being made redundant. Guess why? Carter. I set the department up 10 years ago and have run it for most of that time, and it's a big blow.
I agree much with what I've heard concerning means testing. What reason is there why the magistrates at the end of the case could not make a defence cost order in their own discretion as they could with the prosecution? If that was in excess of what was reasonable, then of course that could be subject to appeal. I presume the government doesn't want to put their trust into the bench, the court clerks and the judges.
Could you please put your hands up for yes? Thank you.
I'm anxious that we're not just talking from our own perspective in our own pocket. I'm anxious that we actually talk about some clients. You know, there are a lot of very, very vulnerable people out there, and you've got on the one hand that vulnerable person and the whole state system up against them, with the police, the CPS and everything, and that's what concerns me as much as anything else.
One of the main points of Carter is that it will limit a market. It will form a closed market.
Exactly.
Those who are complicit in it, that agree with Carter and the government, will be party to a closed market. Firms will hold duty solicitor status. Without duty solicitor status, you will not be able to set up a firm.
Sean Pinchbeck from Hepton Stills in Gaul. I've not been able to sign a protocol because I'm actually the only solicitor in Gaul. So I've entered into a voluntary one with myself. And my personal protocol with myself has been that I won't do anything without a representation order, and I've had full support from the clerks.
Now, I personally would advocate and support strike action, but it has to be effective, it has to be wide-ranging, and it has to be indefinite, which I see as the long-term proposal.
The only way we are going to win in this battle, and battle it is by sticking together, and they all need to come on side. Everybody. Look, the cost of practicing has risen exponentially. It's ridiculous. The administrative burden has become almost intolerable. Being a solicitor is a very expensive hobby indeed now, ladies and gentlemen. We are a very soft target. Let's have a go at the fat cat lawyers. Well, my bank manager looks at me as an emaciated gerbil, I can assure you, and no fat cat. And look, get rid of us, send all the thugs down. And unfortunately, a large proportion of the electorate will agree with that until they, or their son, or their daughter gets accused of a criminal offence. Then they quickly want us. You know, I'm in a system where my paymaster is also the body that I complain to and who now regulates me. Not monopolistic? You betcha. It's a disgrace. My view is we do this. I firmly support Nick Lloyd's motion, and I hope the rest of you will as well. Thank you for listening.
You have the proposal prepared not by myself, but by 4 solicitors in Cardiff. The 4 of us got together, prepared that document. It's extreme, it's volatile, but these are extreme and volatile times. We are in a desperate situation.
Those in favour? All in favour of calling ourselves the Criminal Defence Solicitors Union? What I can tell you is that this message will go back to the Law Society and to just about everybody else we can make listen